The opinions expressed on the Custody Queen Show are for informational purposes only and are not a substitute for personal, professional legal advice. The persons discussed are fictional and not based on actual clients.
I'm Sam McBride. I'm here with Kristen Holstrom. We're the Custody Queens, and we're in Las Vegas.
And we are filming another show in Vegas.
That's right.
You know, Sin City, what is a better place to talk about divorce than in Sin City? But we do have two additional very special guests today. We have, to my left, Dayn Holstrom, managing partner of Holstrom Block and Park, and he is Divorce Authority. And we also have, to my left, Ed Kainen, who is a premier family law attorney here in Sin City. Ed, why don't you tell our listeners a little bit about who you are and what you do?
Okay. I have the largest group of most credentialed family lawyers in Nevada. We're kind of the top family law firm. We've got 5 board certified specialists, and the nice part is if there's usually a big case going on, we have an opportunity to have a piece of it.
That's awesome. And where are you located? Are you downtown Vegas or?
We're out in Summerlin.
Okay. And for all of our listeners not super familiar with Vegas.
That's the west side of the valley up against the mountain.
That's the best side.
That's the best side. Okay. And Ed, what is your website? How can our listeners reach you?
Sure. My website is www.kainenlawgroup.com. It's Kainen lawgroup.com.
Perfect. And we'll make sure we share that information. So for anyone listening, if you didn't catch that, make sure you go to custodyqueensonair.com and all of that information will be available. And you get to watch us and not just listen to us, and you get to check out Sin City behind us.
So thanks for joining us, Ed. We're so excited to have you here. And Dayn, we're excited to have you too.
Well, thank you.
Dayn has become a custody queen as well at this point, so.
I'm sure you've heard him on our past shows, and he will be here for many, many months to come.
Yeah, and if anyone is listening and really wants more tips about divorce, the process, the minutia of the entire dissolution process, check out Divorce Authority. It's on all streaming platforms. Dayn does a really good job breaking down financial issues, custody issues, what is best interest, and gets a little bit more in depth than we're able to do on this show. And if you want to reach Dayn, you can go to hbplaw.com. You can send an email inquiry and it will get to him, or you could just DM Samurai and we'll stalk him and get the information to him for you. All right, so now, Sam, you know, all family law attorneys, we always keep the confidentiality of our clients, and we, you know, that is always the most important issue. But as family law attorneys, we have some war stories.
And we love to share those.
So, Dayn, do you want to share one?
Goodness sakes. Probably not in public. No, there was one that you're well aware of. It was a custody case that I had where it was a strange case in family law. We see it all, guys. And in this case, I was cross-examining the mother, and the mother, I asked the mother, do you want your children do you understand your children often mirror your behavior? And the fact of this case was that the mother had a child with her brother. And I asked her that, and her response back was very profound. She says, he was my half-brother. And that was kind of the end of that.
Wow.
Yeah, and I was actually in the courtroom. I was either a baby attorney, I think I was, because I was going with Dayn to, you know, watch how the process. And I can tell you there were a lot of jaws that hit the floor.
Wow.
And to say that we have heard and seen it all, we have.
Very true.
That one was still shocking. Now, Ed, being a family law attorney in Sin City, you gotta have some stories that our listeners, spill the tea.
Trying to think. Let's see. All right, I can give you one. I was doing a child support and custody case. We had resolved custody already, and it was a case where there was ironically, there were some differences between California and Nevada, because the child support in Nevada could have been as low as $500 a month, and this was a very high earner. He was earning in the tens of millions of dollars a year. And in California, I think the guideline support in California would have been somewhere around $50,000 a month. So the stakes were pretty high.
Wow.
We convinced the court in Nevada to keep jurisdiction, and like I said, it's a fairly high-profile professional athlete. And we're at the final hearing on the day, and we've got it down where we think our award of child support that he's going to have to pay is going to be somewhere in the neighborhood of $500, $1,000, $1,500, but he's going to agree to pay for all the private school and all the medical and everything else. And so we're going in, and all we have to do is close this deal. And I tell him not to show up with the entourage, and of course he shows up with the entourage.
The bodyguards, the glam squad.
I can't go anywhere without my entourage.
So we're sitting down and we're going over the last minute details of what this hearing's going to involve. And I notice he's wearing a bright platinum diamond encrusted watch. I mean, it is flashy as all get out. And I said to him, I said, look, you got
Sounds nice.
It's a beautiful watch. I said, you got to take the watch off. Give it to your guy. He says, no, I'm not taking it off. I earned it. I was like, no, but you can't wear the watch and everything like that. We're going in on child support here, and he's not getting it. I said to him, look, you can't wear a $75,000 watch into a hearing where we're fighting over whether you're going to pay, this much in child support or this much. He gets up, he's practically in my face, and he's offended. And this is a tough guy. And what are you so mad at? I said to him. He goes, you insulted my watch. It's not a $75,000 watch. It's a $300,000 watch.
That's how you know you've made it, when you've insulted a watch. You've insulted, the watch has its own personality and can be offended.
So did he take the watch off?
He did take the watch off. And we ended up with a $1,000 a month award in addition to agreeing to pay all the actual costs for the child.
Comparatively speaking, that sounds like a bargain.
That sounds like an absolute bargain. I think that, if you're a high income earner and child support might be on the table, you should probably become a resident of Vegas or Nevada.
The child support guidelines have changed somewhat, but it's still way more attractive than it is in California for high income earners.
Yeah, one of the things we're going to talk about in this episode is some of the big differences between California law and Nevada.
Okay, so to add on to Ed's story, if you are the high income earner or the person that would be paying support, you may want to talk to Ed and consider a potential relocation before the support order is made.
Well, see, ironically, it was really important in that case because my client had residences in both California and Nevada. And for us, because the person who's going to be paying support, his residences or what controls the child support determination, or what state's going to control it. In this case, it was really important for Nevada to be in control. So as soon as we got involved in the case prior to the litigation starting, we said to him, don't go back to your house in California. We don't want you to get served in California. We made sure everything was still in place to make Nevada, or to be sure that Nevada was his primary residence, and it was for tax purposes and things like that. So as long as we avoided him getting served in California, we were in pretty good shape, because the key for us was we wanted to make sure Nevada had jurisdiction on the child support issue.
Got it, and that parallels the other issues regarding there can be different jurisdictions for different states at one time, and so one state may have jurisdiction over the child custody aspect, one might have jurisdiction, as Ed indicated, for support, and one might have jurisdiction over the marriage or the property of the marriage.
And alimony can be in different jurisdictions.
Absolutely,
really,
yeah.
Every one of those, that's the amazing part about family law, as we all know, is you can have litigation that involves subparts of that litigation in 3 or 4 different states, depending on what people's means and location are.
Under federal law, that's literally called the doctrine of divisible divorce, that you can cut it up into pieces and separate the issues.
And so, Dayn, how is jurisdiction different with support and custody with respect to who would be, for instance, Ed was saying that the pay, or if he was in Nevada, the Nevada would control. That's a little slightly different for custody.
It is different. In fact, we have something called the Uniform Child Custody Jurisdiction and Enforcement Act, a mouthful, UCCJEA. And it's been adopted, I believe, by all 50 states in almost the entirety of it. There are subsections that are different, but the gist of it is where the child's quote-unquote home state is decides where we're going to fight about it. So very often what happens is one parent will leave California and go somewhere else. Maybe it's Nevada. And when they arrive in Nevada, they will wait there 6 weeks and then file for divorce and ask for custody orders. Well, that creates a problem for the Nevada lawyer now, because he says, wait a second, you've only been here for 6 weeks. In order for Nevada to become your home state, you have to wait up to 6 months unless there's emergency jurisdiction. So that creates issues. In the meantime, the parent in California filed and says, I want custody orders in California. Under that scenario, it is quite possible that Nevada might litigate the marital status because they acquired jurisdiction, in theory, and in California might have to litigate the custody issue, and then whoever the payor would be determined by which state the payor is in.
And the good part about all that is the uniform laws that Dayn mentioned, is that most states have adopted these uniform jurisdiction laws. So theoretically, all the states are making these jurisdictional determinations on the same basis. So if there's a custody dispute, the law in California is going to be 98% the same as the law in Nevada as far as determining which state's going to be in the driver's seat, and it gets the judges talking. Same thing on child support, same thing with parentage, all of those kind of things. They're generally, operating from the same playbook to determine which state should have it, to avoid what we call forum shopping.
That was the reason why it was created, was because parents would literally plan a move to a more favorable state that had better laws for what they thought their case was, and try to move just to get the rules of that state applied. This blocked most of that. There's still some of it, but as Ed pointed out, one of the requirements of this act is that the judges are required to talk to each other, literally have a phone call to talk about the facts and make a decision between them which state is better suited to resolve it based upon literally the residence of the child and the circumstances of how they got there.
And with all of the move-aways going on, I can say that Sam and I deal with this very often. I know that we've had several evidentiary hearings on these exact issues. So everything we've been talking about today had a lot of complicated issues. And Ed, I bet you have a lot more cases coming up in Nevada, because I can say that a lot of California residents are moving out of state. And from what I can see from my social media, Arizona and Nevada are two popular states that people are moving to.
Yeah, we see a lot of transplants from California. The biggest advantage for most folks is that there's no state income tax in Nevada. And so when you look at the 9 or 10% state income tax in California and compare it to if you can take your income in Nevada, it's a huge savings for most people. So we see a lot of transplants both because of that, and frankly the cost of living is a whole lot more accessible. So we see a lot of folks from California.
Now that's a great question to decide. That gives an unfair advantage to your hockey team and your football team to recruit new athletes, because they don't have to pay income tax.
And I can accept that.
Sure.
I can live with that.
For sure.
All right.
That would be very appealing if I was a professional athlete.
Ed, when we were talking about getting ready for this show, you shared that you had some strange, we were talking a little bit about war stories, and I think it's important that we hear about one of them where you've had some fairly short marriages in your professional career.
There's a couple of cases that have gotten some notoriety. One involved a 55-hour marriage, and one involved more recently, one involved an 88-hour marriage.
We call that a long-term marriage.
Yeah, that could be.
The one that was 55 hours, did that have anything to do with Hit Me Baby One More Time?
I can't say.
Did you have any marriages at the Elvis Wedding Chapel? Because we were talking about that on our last show.
I've got to tell you, I have attended a wedding ceremony from the Elvis Wedding
Chapel. I have
too. It was one of the most, and they do two different versions, or at least when I saw it. One was kind of a serious one where they quoted a lot of the songs and did it in a nice romantic way, but the one I saw was hilarious. And the officiant, I mean, I gotta tell you, I don't think I've laughed that hard for about 20 minutes. It was like watching a stand-up routine, and he incorporated all sorts of Elvis songs and everything else.
Well, and you've talked me into it. I think I found my wedding venue.
It was wonderful. It was for an aunt and uncle of mine who were renewing their vows after 50 years, and it was a blast to attend.
Yeah, the one that I saw, ended up in divorce. So you got a 50-50 chance there, Sam, like at the wedding chapel.
Well, good news, I'm in the business.
You know a few good attorneys. All right, Dayn, do you guys want to get into some of the distinctions between California and Nevada?
Well, one of the things that Ed and I were talking about that was really very profound, besides the child support that he just brought up, that I thought was great. And there's a concept in California law that is subject to a lot of litigation, and it's called the date of separation, for most people, it's kind of common sense. Somebody moves out, we're legally separated. And so California law has a lot of issues, particularly around businesses and some other assets that are tied to the actions or the work of one of the spouses. But it also, as Ed pointed out in our discussion, can be very much just circumstance and serendipity. So the ideas of California, if you separate in January of 2020 and you don't get divorced until December of 2022, that gap of time that you're in, any assets that you acquired on your own are, under California law, your separate property because you earned them after marriage. Ed, how's the law in Nevada?
So people talk about separation all the time because we hear about it from California cases. You guys can spend the sometimes first year or two of litigation fighting over what is the date of separation. And the key is that we both have community property, but the difference is when that community, or when the community property, when our property ends and it becomes my property and her property kind of thing. And so in California, it becomes a date that's set in stone, and then you guys can spend your time lollygagging and litigating until you get to a final conclusion.
Yeah, we don't lollygag, but thank you.
No lollygagging.
Okay.
All right. On the other hand, in Nevada, our law says that community property continues to accrue during the entirety of the marriage until the divorce actually ends, which presents some challenges because sometimes it's a moving target. You've got the cases evolving and things are happening while the litigation is going on, so you're not dealing with a fixed point in time in the back. But the key thing, or the benefit that I think, or the thing I like most about the way we do it rather than California, is it prevents the misuse of separation, where somebody gets a little inside information that they're going to get a bonus, or they're going to some good news is going to befall them economically, and all of a sudden they decide to strategically separate and end the community so they can take the windfall after the community. Or they're going to stay longer because there's going to be something bad that's going to happen. We don't get the ability to do that.
What the example that I often use for the clients to try to explain the concept of data separation from an asset perspective is this one. I say, hey, if the day before separation you find $1 on the sidewalk and you go out and buy a winning lottery ticket that wins $1 million, that's community property. Okay, because the dollar was yours during marriage before separation. But if you find that same dollar the day after you separated, it's separate property. That's the law. Under Nevada law, doesn't matter.
Right. You can find that. You can been separated for a couple of years while the litigation is going on, and you buy that lottery ticket on the way to court. You win $1 million, you're giving up $500,000 of it.
So if say wife is downstairs having a divorce party in the casino, because that's a new thing now, and she's celebrating her divorce because the next day she's walking into court with you, Ed, and her judgment is going to be final, and she wins the $10 million jackpot bonus. You're saying that is community property.
That is community property. That is absolutely community property.
I'll still take the win with the lotto, though.
That is crazy, but I could see how, it eliminates a lot of litigating over that date. But Dayn, what you were saying, because we spend a lot of time as attorneys defining separation. Mm-hmm. Are you living together because the cost of living?
Well, and I've talked about this before and also on my podcast, but there's a case in California called Marriage of Baragri. It's called the Captain's Paradise, and that was a 5-year litigation over the date of separation because the doctor was living on his sailboat with his receptionist girlfriend, and maybe it was a doctor, not a dentist, I don't know. Anyway, the gist of it was, wife's attorney says, you know what? Because husband was going over to the house and having dinner there and dropping his laundry off because they didn't have washer and dryer on the sailboat, and she was doing his laundry, the gist of it was they're not separated. So, and it was an equitable argument, and I again love the reasoning of that case, that it was well reasoned and well thought out, but it creates that issue. I too have a case with probably $30-40 million of assets going on right now that would have settled like that.
So Dayn, what's California's definition of date of separation?
Oh wow. It is a combination of two parts. It is the current state of the law, because it's morphed over the last few years. It is a combination of both a subjective state of mind of either party that the marriage is over. Now that doesn't just mean I moved out and I'm angry. That means it means that I have made a decision that the marriage is over.
Separate indefinitely.
Now, it's a current state of mind, which means that's the problem with California law. It can change, okay?
Because what if you go to counseling a month later?
Counseling, makeup, sex, dinner, whatever. All of those things can create a change and a movement in the date of separation. And that's what makes it a moving target, as Ed was talking about, is that it can change. And the combination is not just the state of mind, but also what's called the outward manifestation. What do you do? Did you file for divorce? Did you change your bank accounts? Did you not file taxes jointly? What did you do? Did you, like Dr. Bragry, did you go to a convention, bring your wife, and introduce her as your wife?
Right.
Okay.
And the public received her as your wife?
Exactly. So it's if you're acting like you're a married couple, you may still be a married couple, even if both of you think you're not. So it's a very complicated area of law.
And it's so complicated that if you have a question about date of separation, either here in Sin City or in California, make sure you reach out to the custody queens, Dayn Holstrom or Ed Kainen if you are in Nevada, because this is a long thought out analysis and it is fact dependent, and you really want to have a consultation with a qualified attorney.
That's
like
exactly right.
The custody queens and Dayn and Ed. So make sure you reach out, set up that consult, plan ahead, and make sure you call us at 1-800-419-7772. That's 1-800-419-7772. And I did have one more last question for Ed. So when you're, determining the value of the businesses or the assets, I could see how that would be a little bit different of a process than in California.
Yeah, it's a lot more challenging because of the fact that we don't have a fixed point in time. So we usually there's two different valuation folks that are involved. And so normally there's an agreement that they can reach at the closest quarter end or semi-annual end prior to trial. So if we have an October trial, the valuation folks might agree, look, for all purposes, we're going to agree that June 30th is going to be the valuation date that they'll both use. And if something relevant happens between June 30th and the trial date, then we can use that as an adjustment to valuation.
Like a lotto ticket.
Like a lotto
Or
ticket.
Winning one.
Stock. Look at the real estate market
Well,
right now.
the issue, though, that Ed talks about is really huge, because in California, that's the Pereira Van Camp we touched upon, is if there's a 5-year separation and the business has either crashed or exploded, that court can say, hey, that's a separate property of the operator's spouse, and the person who's not operating the business may not benefit from it.
Right.
But under the Nevada theory, again, what if the business crashes and burns, and the party burned it down?
Right.
It's possible.
Right, and ironically, we actually use Pereira and Van Camp in Nevada. We use them for the same purposes that California uses.
Wow,
They're both California cases.
Yeah.
And people don't know it's the Van
So
Camp
you
fish
like
sticks.
some things from California, okay? You need us too.
Here's
It's
the
like some
ironic
cherry
part.
picking
This is no joke. Our entire body of appellate case law, from 1864 to the present, can fit basically in one bookcase that's about 4 feet wide and maybe 6 feet tall. In other words, there is not a depth of case law. So we rely on California a lot, where there's similarity in the laws. It's just in areas where data separation, for example, is done differently that we go in a separate way. We also didn't have an intermediate appellate court until a few years ago.
Wow.
Interesting.
So
Yeah.
so we rely on California an awful lot. But to use your example, if you look at Pereira and Van Camp and you choose a valuation methodology, what if the time of the divorce was January of 2020, and all of a sudden you're in a public service business and the divorce is in June? Well, the whole world changed in March of 2020.
Right.
So now you really have to deal with that. Same thing if you valued in the fall of 2020, and now the world has come back a few months later, it changes again dramatically. So those numbers are moving targets, and you have to fashion some level of equity in the valuation of a business that way.
And they still do under California. Basically, what they look at, and my example used to be, if you had a real estate business in 2008,
right?
When the economy crashed, and now of course we all use COVID, but they look at that, and it's whether or not it's rising or falling as the results of the efforts of the spouse is what's determinative of the alternate valuation date.
Well, not only for the alternate valuation date, but for what the future earnings. In other words, when we look at valuation, we're looking, a component of the valuation is not just your book value, but what are your expected future earnings?
Yeah.
Well, if you're looking at expected future earnings of a real estate business in Las Vegas where development was going gangbusters in 2006 and 2007, and all of a sudden you're dealing with 2008 rolls along, the expectation of somebody in real estate, unless they're doing REO or foreclosure sales, really wasn't very promising. So the universe can change dramatically in terms of future earnings.
Yeah, those are the kind of things that make for really challenging cases.
And that is when you call and you set up a consult with Ed Kainen in Nevada and the Custody Queens and Holstrom Block and Park in California. And for everyone listening and watching, Pereira and Van Camp are the name of two cases that are help used to determine the value of businesses. And Sam, I just wanted you, for our listeners, why don't you clarify a little bit about how California deals with the data separation and assets? Because I don't think we touched so much on California. I know we hit it for Nevada.
Well, I mean, Dayn was kind of talking about what the definition is of the date of separation, but in California is a community property state, and the way that we look at the estate is from the date of marriage all the way to the date of separation. And so that's why we have a lot of litigation associated with the date of separation, because the community property state is defined in between that. So if you earn something or you acquire something during marriage, prior to the date of separation, with some exceptions, that's going to be considered or characterized, as we say, community property.
And the community is the spouses, for anyone listening and may not catch on. The community, it's, for family law attorneys, we always just say the community, but that is the two spouses, generally the husband and the wife, but it's two spouses.
Yeah, we talk about yours, mine, and ours. Yours and mine are separate property. Ours is community property.
Right.
Yeah.
And that is a source of a lot of divorces, because one spouse says, what's yours is ours and what's mine is mine.
Yep.
Well, and I can tell you at kind of my age group, and everyone knows on the show that I'm 40 because we always talk about, the evolution of my age, but I can tell you that I have a lot of friends that, they have separate bank accounts, and that's just the way that a lot of people do it these days. They have a joint account to pay some bills, but both parties have separate accounts, but people don't really understand that those separate accounts are generally still community property, besides, if you have a prenup or...
That's a whole nother subject.
A whole nother subject.
It's a whole nother day. It's a whole nother subject, but if you are making money during marriage in California, that money is community money. So if that money goes into a bank account, even if it's a side account, it's still you and your spouse's money.
Yeah. And I have one last question for you, Ed, 'cause we'll have to have you on again, because I have so many questions running through my brain right now. But how long is the average divorce take in Nevada?
It varies. We don't have a waiting period. We don't have a reconciliation period. So I could file a divorce and have it signed this afternoon if everybody agreed on everything.
Wow.
Hang on. You can get it in a marriage that lasts like 48 hours and be out of it in 48 hours.
Yeah. In fact, the 55-hour marriage that was 55 hours between the marriage and when the divorce was signed, if you remember back to that particular case where the party shall remain nameless. The 88-hour marriage, which was more recently, was really 88 hours between marriage and when the divorce was filed.
That is crazy.
Wow.
But the difference is that if everything's agreed, all you have to do is bring the paperwork down to the courthouse, file it, and have a judge sign.
And I actually 100% support that, because a lot of times Sam and I will negotiate a full agreement, the disclosures are done, and then you haven't met that 6-month waiting period.
And the reason why, for everyone listening, Kristen and I think, and probably everyone, but Kristen and I think that is so amazing, is in California you have a 6-month cooling off period. So you can't, unfortunately, call us and say, Sam, Kristen, please divorce us quicker. In California, we can't do it. We might resolve the issues, as Kristen said, but we can't get you to a status of a single individual sooner than 6 months.
And that's one of the problems that creates, is you get the people that have been separated for 5 or 10 years, and they're with somebody else, and they want to get married. And they'll call you up and say, the wedding's in 3 months, and I need a divorce.
Yep.
And we say, God, we're sorry.
That happens. That happens more often than you think.
See, there's an irony there, is that California is one of the first states to go no fault.
Yes.
And it's been around for a long time. And that was really to take away obstacles to divorce. But California held on to that waiting period, which is really that reconciliation period that people really don't know what they want, and we want to foster long-term marriage and avoid the acrimony. And they didn't abandon that. Now, I can tell you, one of the solutions that sometimes exists is if your clients make a good faith relocation to Nevada.
Hey, you knew exactly where I was going.
Nevada has no waiting period, and the period of time it takes to become a bona fide resident of Nevada is only 6 weeks or 42 days.
Wow.
Wow.
So everybody listening, there's some great info there.
I see a side business, you know?
Okay, so Ed, before we wrap the show up, and because we're in your neck of the woods and we are in Sin City, as evidence behind me, what is like a hidden gem that, you know, Sam and I may not know about, or anyone coming to Vegas should see or eat or do?
Okay, so you've got, every one of these casinos has their own unbelievable dining experiences, celebrity chefs all around this town. One of my favorite little restaurants is a place called Chicago Joe's. It's down on 4th Street. It's in a house that's probably 800, 1,000 square feet tops, and it's some of the best Southern Italian food you're ever going to try.
Oh, that sounds
great.
good. We'll have to have Ed join us for our next trip to Vegas.
That's right.
Absolutely.
All right, Sam, you want to wrap us up?
All right, it sounds like we are all out of time. Thank you so much, Ed and Dayn, for joining us on Custody Queens on Air. Please catch our episodes on YouTube and all forms of streaming media. Please also make sure that you listen every Saturday with Kristen and I at 8:30 a.m. on Go Country 105. You can give us a call at 1-800-419-7772. That's 1-800-419-7772.
And thank you, everybody, for joining us. It was fun, and I love being in Sin City. We should do this again. And don't forget, you can go to custodyqueensonair.com to see our videos. You can go to custodyqueens.com to DM us, send an inquiry, talk to our intake team. And if you are looking for a consult with Ed and his team, you can go to www.kainenlawgroup.com. And if you don't know how to spell that, check out our social media for all the information on Ed. And it was an absolute pleasure doing this, and we will definitely have a part 2 in Sin City.
That's right. And remember,
Let law